Hi, my name is Ricarda van Meeting from the University of Passau in Germany. Here I work at the Chair for European and International Information and Data Protection Law under Professor Hennemann. Our chair here undertakes researches and publishes on different aspects of data protection. So one of the main challenges at the moment in this field is data protection in the context of AI, of artificial intelligence. Therefore, I would like to give you a short overview on the challenges that come with legal regulation of AI today. So on the one hand, AI development and deployment requires a large volume of data. The more data is used on the input side, the better is the output. But then on the other hand, data protection insists on first, data minimization, second, purpose limitation, and third, lawfulness, fairness, accessibility, and transparency in data processing. So as it is probably obvious, this hinders the efficiency, accuracy, and reliability of AI results. It affects the central purpose of AI, which is to collect as much data as possible to facilitate machine learning and hence intelligent decisions. So therefore, our research on AI and data protection is geared to find some middle ground, some level playing ground between the use of AI, privacy, and data protection. What is needed is a system that can provide protection to individual privacy or group privacy and security to their data, but a system that also allows machine learning processes in a way that produces reliable and credible results. Our hope is that regulatory systems will evolve around the globe that support artificial intelligence development and deployment while also addressing ethical and security concerns. So one of the main problems with regard to creating such regulatory norms is that regulators fear a resulting loss of innovation and fast transformation. This is the case especially in a field like AI and big data, where changes happen so quickly that legislators have a hard time adapting to it. Therefore, it is notable that there is no specific AI regulation on the African continent so far. If there is regulation, it is mostly encompassed in data protection law, where automatic decision-making is addressed. Examples for such regulation on automatic decision-making or generally on data processing exist on all levels of legislation in Africa. So first of all, on the level of the African Union, there is the Malabo Convention on Cybersecurity and Personal Data, which also applies to automated processing of data. Then there is a level of the regional economic communities of the RECs, where there's also various legal frameworks, like for example, the EAC legal framework for cyber laws, or the SADC data protection model law. And then, of course, there's the national level with its various options for legislation. And there are several African countries which have already enacted some kind of data law or data protection law. For example, in Tunisia, this being the Loi portant sur la protection des données à caractère personnel. I hope I said this right. So the law on personal data protection, which applies generally to data processing and therefore also in an AI context. But once again, this does not include specific AI regulation. But then in the European context, it is also notable that the EU has not given concrete answers with regard to legislating AI either. While much of the general data protection regulation, the GDPR, may apply to AI in general, there's also Article 22 GDPR, which focuses on automatic decision-making and corresponding information duties, which are also within the GDPR. However, these are not applicable in all cases, and they do not offer a sufficient legal framework. Now, after hearing all this, you might say, well, let's leave AI to itself and to the free market, and the free market will take care of reasonable deployment of it. However, such an unregulated scenario can pose great threats. Data, especially when collected and sorted in a big manner that AI is obviously capable of, will be especially threatening to further competition if it is collected by one major player on the market. And then, of course, it can pose a big threat to individuals or groups that don't have control over the usage of their data anymore. Possible answers, therefore, could be either not to collect data at all or have strict rules on its further deployment. This would then again endanger innovations such as potential useful deployment for the common good, for example, by improving aspects of everyday life. So therefore, there are some central questions that we have to keep asking ourselves in the coming years. First of all, how can a reasonable collection and usage of data be incentivized so that corresponding legislation is enacted? Then, if there is such legislation, how can it be framed in a way that it does not hinder innovation while sufficiently protecting individual and group information? And third, how can there be maximum participation of everyone when it comes to controlling and developing artificial intelligence in the future? Now, I am not here to answer these questions today. Moreover, I want to pose them and spread awareness that they need to be considered in the future deployment of artificial intelligence. Now, for African countries, the answer will likely not be the adaptation of a regulatory system that functions anywhere, or that functions in a specific part of the world. Each African country is unique in its culture and society and might have a different concept of privacy and how it should be protected. Therefore, I want to encourage all of you to keep up the dialogue on artificial intelligence and think about the opportunities, but also what legal frameworks might be needed in your surroundings. Thank you for listening, and I hope you enjoy the rest of the conference.